Mr. Manning?
May it please the Court. You know, after listening to all that adjustment of the tensions between the state and the individual, I almost feel this is prosaic, but it's still important to my client. And it involves a couple of matters. I'd like to just give you a brief overview of how I perceive the problem that's been presented to you. This is my summary of what's occurred. First of all, I think you have to ascertain the theories upon which the parties below were proceeding in connection with this case. You had two petitions that were filed here. The first petition was a petition that involved very specific application of the law, but it was an application basically for a modification of the final judgment based upon a substantial change in circumstances. It involved the disposition of some assets that had been owned by the parties during the course of the marriage. During the course of the proceeding below, those assets were disposed of, and then there was an amended supplemental petition that was filed. Now, this petition as well, the second petition, was the petition which asked for a modification of the final judgment. In fact, the theory upon which this case was tried was not embraced by that particular petition, but it was tried by consent. So I will accept the fact that there were two theories that were the substantive basis for the trial of the proceeding below. The first theory was there a substantial change in circumstances which warranted modification of the final judgment? And the second theory was there a grounds to specifically enforce the terms of the final judgment, which incorporated the mediation agreement which the parties had made pursuant to the original final judgment? Now, the reason I've analyzed it in that fashion is because if you do, it makes it a lot easier to understand why the trial judge erred. First of all, he made no finding that there had been a substantial change in circumstances, and so you're not going to be able to affirm the disposition based upon his finding of a substantial change in circumstances. Therefore, what we're going to have to do is analyze the conduct of the trial judge in terms of his trying to specifically enforce the terms of the final judgment. Now that really brings us to what we're going to have to do, and that is, first, you must look at the original mediation agreement that was incorporated into the final judgment. You're looking quizzical, Judge Northcott?
I'm formulating a question for the time when you get to that.
All right. All right, and then after you look at the mediation agreement...
I'm at a different table than I'm used to when I heard you argue.
All right, sir. All right, good enough. Then you have to look at the... No, that's not a problem. And then you look at the final judgment to see upon what terms and conditions that you could bring the action for the specific enforcement of the final judgment. So I'm going to ask you to bear with me just a moment. I promise not to read much today, but I'm going to at least mention to you that this final judgment, this mediation agreement, contains the basis upon which we have to examine the quality of the conduct of the trial judge. And that involves a trigger. First, we have to see what it was that the parties agreed to in the mediation agreement. And paragraph 6 of the mediation agreement forms the predicate for our being here today. There are two paragraphs of the mediation agreement that are relevant, paragraphs 4 and 6. But paragraph 6 is the one that really provides our being here today. Paragraph 6 of the mediation agreement is titled Child Support. Strange enough, and yet that brings us to consider what's here, because paragraph 6 says the payments of alimony and child support shall commence a certain date. And this is the operative language. The alimony and child support obligations were grounded upon the following. First, a monthly salary for the husband of $1,250. Second, additional taxable income for the husband of $7,247 per month, and I did say taxable income. And third, taxable income to the wife of $1,326 per month. Now, those were the elements, and those elements were set forth further in a certain little document which was attached to the wife's exhibit below, and it appears at Record, Volume 12, pages 1462-1476. And it's titled Hannah versus Hannah, Husband's Estimated Current in 2009 Income, Financial Affidavit Support. Now, this was a wife's exhibit below, and she attached it, but it was the original document that was used by the parties in connection with establishing the original mediation amount. And that document says exactly what I've just read, except in a more particularized form with respect to the predicate upon which the mediation agreement was entered and upon which the final judgment was, which incorporated. It stated, total income of the husband monthly, $54.97 from salary, interest income, dividend income, and rental income. And of course he had deducted the $3,000, but the actual total he had at the time was $8,497 per month, or as you'll see throughout the briefs, $101,000 per year. So that was the income upon which this mediation agreement was founded. I might mention immediately.
And was that the income shown on his tax return that year?
Your Honor, they didn't use the tax return that year, and that's the interesting point, because the tax return for that particular year wasn't filed until 2010. And so when you see the observation made by the trial judge below, which he used as the predicate to show there had been an increase, mainly a $6 or $7 million loss, that tax return upon which he relied was non-existent. It was a non-existent document at the time that these parties entered into this agreement. So I'll lead right into that point. The trigger for operation of the increase is going to be whether or not there was an increase in income. The obligation was on the former wife to establish, first of all, that there had been an increase in income between the time that this original agreement was entered and between the time that she made her application.
And the language about, when you said paragraph 6, when I looked at my own documents, I looked at paragraph 6 of the final judgment. I didn't realize they lined up the same numbers. But in the final judgment, it's talking about just what you said, an increase in the husband's income. And I guess my question is, without more specific definition, why shouldn't the law be that the word income means the definition in Chapter 61? Because this is a...
I frankly would have no problem with that. I frankly have no problem with the employment of the definition of income pursuant to Chapter 61. Indeed, it supports the first aspect of my analysis. That is, what is the income that the husband had during that particular year? And, it's income available from all sources and so forth. Right. But what it doesn't embrace is the fact that the husband unexpectedly that year, as a consequence of the collapse of the construction industry, experienced a loss of many millions of dollars, I'll just put it that way. And we're not dealing with the tax return for purposes of establishing the income other than is being evidence of what the husband was reporting as income. What isn't here, and I think it's an important distinction, is, to me, as a former tax lawyer, taxable income is utterly distinct from other income that you may report on your tax return. You have various numbered entries that you can report: dividend income, interest income, rental income, and indeed those were the elements that were set forth in the original agreement that was executed by these parties in the mediation agreement. Taxable income is the last entry that appears down there. These parties obviously were not giving any consideration to loss, and I cannot say that the record supports whether that loss was accrued earlier or later in the year. I can't say that because I don't know, and I don't think any of us will ever know, because it wasn't a consideration of the parties at the time they executed this agreement. So we start out with that point. What was the income at that time? And I think the income, as established by the record clearly, was basically $101,000 per year. And it was incumbent upon the wife, as a condition preceding to seeking a modification of that income, to show that there had been an increase in his income since that time. And that brings us maybe to the question you're formulating, and that's the question of how do we measure the income of the husband during the year in which this proceeding took place, which was 2012. And that in turn raises a couple of significant points. One is, do we look back and forth to the tax returns? Now, keep in mind, this trial judge below was doing just that. For some purposes, he would invoke the tax return as being the basis for his analysis. Other times, he would reject the tax return. In other words, he said very clearly he was looking at the 2009 tax return, which was filed in 2010, as the basis for establishing the floor upon which he would measure an increase. And yet, he later on quite clearly said, I'm going to look to all sources of income. I'm not going to be bound by a tax return with respect to all sources of income. And it was that assumption that he could look to all sources of income which enabled him to impute income to the husband. Now, I would ask you to consider for a moment whether or not there was any imputation of income initially. In fact, he made the observation that there was, but it's clear he was confusing what was being said in the exhibit. The exhibit upon which he relied in making the statement that, well, I can impute income because originally they imputed income, he relied upon the exhibit that appears, to which I've just given you the record citation, which is why I gave it to you, because there is no reference whatsoever to imputed income in that exhibit. I would therefore say that finding is based on the absence of any competent substantial evidence, because there's no testimony to that effect as well. So he's wrong on that point. That finding is without evidential support. But that
Is what's going on in the judge's mind, and in this case, legally an imputation of income? I get confused sometimes as to exactly what, I mean, it seems to me that on the investments, imputing 5% income versus 1%, that's an, I gather, I agree with that being an imputation, but some of these other things don't feel like imputation.
No, and they don't to me either, and I'm not good. It's not my job to criticize a trial judge when I know what they have to deal with in terms of how the case was presented to them. What I have said is I'm doing my best of all to show you what was actually tried to him and why the first theory, that is the modification under traditional concepts of Chapter 61, is not sustainable, but what he did in order to be sustained under specific enforcement of the final judgment. And what I'm suggesting there is I'm coming right to the point that you're raising right now. Upon what theory did he decide he was going to impute $191,000 of income per year? And this is where I'll burden you again with one other document which you have to look at. And this is this document that appears on record citation, is volume 13, page 1605-1615. This is the former wife's exhibit. Now in there you'll see what she did. This is where the judge got his basis for imputation of income. In fact, it says in the second line from the bottom, imputed annual investment income, $191,979. Let me tell you why this document is so troublesome. What she did was take a substantial portion of the assets which the husband had received in connection with the original dissolution of marriage, the ones way back in 2009, and she imputed income to that. Now that imputed income bore no relation to what income was actually generated for that particular aspect of his assets. She imputed income not only to the money he had put in the U.S. Ameribank Money Market Fund, which is the tax refund, she imputed income to his share of the equitable distribution of marital assets, which was not done in connection with the original agreement of the parties. To do that, she then added another $30,000, and she reached a total of imputed investment income of $191,979. She had to use that particular number in order to establish the first condition to be in the court in the first place, that is, that there had been an increase. On cross-examination, I must tell you, she admitted one thing. And this cross-examination, which is quoted in detail in our reply brief on page 8, in which she admitted to the court asked this question: are the differences in the incomes they're not imputing the 5% and you are? And her answer is, yeah, correct. And in fact, if you look at the documents we have cited in the brief, you'll see the same thing. You'll see our expert witness testified that the man's annual income was $38,000, and if you take away the $191,000 that she imputed as income, it shows that his income was around $40,000 a year. So either way, the key issue in this case is the imputation of income. And by what authority did this trial judge below think that he was entitled to impute income when it was the wife who was seeking specific enforcement of a final judgment based upon a mediation agreement in which there had not been any imputation of income and no provision for imputation of income, especially when the parties themselves state that the mediation agreement, and I'm using their words, are grounded upon the following considerations, and then listed them 1, 2, and 3. And that was the point I was trying to make. Yes,
well,
sir.
if we, at the bottom, aren't we talking, and this is actually a variation on the question that I was forming, but I've abandoned that one. But the difference that it seems to me that we're talking about here is that a mediation agreement that uses the term income. And Chapter 61 actually, when it talks about paying alimony, it does not talk in terms of one party has the income. It says one party has the ability, the financial ability to pay. And that seems to me to be two somewhat different concepts. Income is a subset, you know, of the other. But this is not a case where the action, as you say, was just a straight 6114 modification of the final judgment. This was a enforcement of a mediation agreement, was it not?
Yes, sir. And
Which used the term income.
it used the term income.
It seems to me that if we were in a situation where we're talking about a straight ability to pay, then we would be looking at whether a judge abused his or her discretion, for instance, as you point out, by applying a potential rate of return to all of the assets of the person versus you know, someone who has $800,000 earning 1%, and the judge recognizes that they could earn, you know, more than that, and that goes to ability to pay, not income.
And that in turn, I think the corollary with respect to ability to pay is when there is a support obligation that's been established, and that's why we dealt with the conduct of the husband in this particular instance. In other words, the parties themselves contemplated that this man, and the testimony I think supports this point, contemplated that this man, which is why the wife allowed the husband to receive the tax refund and put it into the company. The conduct of the parties themselves supports the proposition that this man was a businessman who, because of his having a dust-up with the Bank of America, recognized that he was not going to be able to obtain the type of financing in the future that he had had in the past with respect to the maintenance and continuation of his business. There was never one jot of testimony that he was trying to avoid any type of support obligation. Indeed, to the contrary, he paid beyond his support obligation in some instances. What he was trying to do in this particular instance was to keep himself in a liquid position with, yes, sir?
You're just down to 4 minutes.
Thank you. With respect to the maintenance of his assets.
And what I was going to suggest in terms of, you know, okay, so you can have an argument about what he should or shouldn't do with the cash. But in a typical situation where we're not talking about an agreement that says specifically income, you might say that a judge would have committed abuse of discretion by observing that, well, you've got this much equity in your real estate, and if you were investing that, you could get 5%, and that contributes to your ability to pay. Just as a practical matter, in most cases, I think that would be an abuse of discretion.
That's correct.
You would have to, you know, borrow out of the equity out of your home in order to pay.
This instance is different, as you're leading to right now. This is where we have a specific, you're interpreting a final judgment in which the word income is used for very specific purposes. And this is not an abuse of discretion case. This is a case of error as a matter of law. And Judge, I'd like to reserve that 4 minutes, if I may, please,
Okay.
sir.
Good morning. I'm Lorena Kiley here on behalf of the appellee, Ms. Tiffany Hanna. Mr. Manny and I were not involved at the trial level, so there are differences between how we are presenting things on appeal than below in the trial judge. I understand where Mr. Manny's coming from, and I'm not faulting him for this, but in the appeal, he's now arguing that the trial judge should have looked at substantial change in circumstances below. I agree, and that was the position of the former wife below, and that she argued that, and the trial judge said, no, I'm not going to do that. And now they've switched positions. It's my position that if you look at this case, the equities of this case, this court should affirm no matter what the agreement says, because the agreement did not prohibit either party from seeking a substantial change in circumstances based upon a regular standard. Here, what we've got is the husband's net worth increased $2 million from the time of the final judgment, showing that he had...
The order on appeal, though, isn't based on a substantial change in circumstances.
No, it absolutely is not. And I agree that it's not. And, you know, you could always reverse, send it back for an evidentiary hearing to have the judge redo the whole thing, because I think he should have.
With that, and I recognize that you know, neither of you were at the trial, and I gathered the husband represented himself, was pro se.
No, he had counsel.
But in any event, if you're going to proceed on that kind of basis, And, you know, it seems to me that, of course, the largest change of circumstance is receipt of this big pot of cash. But now, though, you've got a potential for an estoppel. You know, if she had said, look, don't give me a share of the cow, I'm not going to make a claim to that, put it in your business, you know, and this is what he does. But then she turns around and says, but you got to give me more alimony. You know, and I'm not suggesting that defense would necessarily prevail, but there it is. You know, if the case wasn't tried on that basis, it's hard for us to say what defenses might have been raised. You know.
Sure, and I appreciate that, and basically, but my response to that, even though we're not really going down that road, is that the agreement on the tax returns did not prohibit her, and this is a separate agreement from the agreement we're talking about now,
Right.
did not prohibit her from the income.
If it did, section 61.14 would have given her the ability to get out of the agreement because of the change of circumstances.
Correct.
While we're on the side trail, assuming the order is based on the marital settlement agreement and the language in the final judgment, and the $3,000, I'm not comfortable in finding that that was the maximum amount that fit within the agreement to head towards standard of living in the marriage. I'm not quite sure where the $3,000 came from, and so if this order stands, what does either party need to do in the future if they want to seek a modification?
I think based upon their mediation agreement that, you know, there's two things. The regular substantial change in circumstances is still available because there's no waiver of that in there, and also the additional contract language about the increase in income, and it's not defined in the agreement.
So you think you can go back on increase of income under the MSA over and over and over again if life goes well for the husband?
If life goes well for the husband, absolutely, up until some defined point that's the marital standard of living, which unfortunately was never defined either. You know, we don't really need to reach that because she clearly needed more. It was conceded below she needed more. It just, and the amount actually awarded, the additional $3,000 still wasn't enough. So we don't really need to get into that as much.
And this is just a side issue, but we're all talking about alimony here. Was there an adjustment to child support at this time as well?
Yes, and there was a subsequent order, I believe, that was entered that dealt, that's not at issue here.
Okay.
Going back to what I was saying, is I think you should affirm no matter what, just because of the, you know, you could send it back for an evidentiary hearing because I believe the trial judge should have considered that as well, and the former wife argued that below, and the former husband objected, and the trial judge, I think, erroneously agreed with the former husband on that issue, because again, the equities show he clearly had an increased ability to pay. He received $2 million. His income, no matter what it is, was more than the minus $7 million he had at the time of the final judgment. I apologize, but I'm probably going to bounce around a little bit in response to Mr. Manny. Sometimes when I listen to Mr. Manny, I start to believe him, but then I have to think what he's just said.
I used to be there.
I try not to listen to him too much. Okay. And again, if you accept the former husband's argument that what we're talking about in this agreement is taxable income, I would submit that the tax returns are the best evidence of what is taxable income, which clearly show that his income increased from the time of the final judgment based upon the schedule that was prepared by the former husband's own accountant, and it was his personal accountant, not an expert accountant that was hired for the proceeding. If you also look at, again, the former husband's argument about the baseline, the $101,000, if you impute income to him based upon, you know, he had $3.5 million in investable assets. If you impute income to him on that, he clearly exceeds that, far exceeds that amount now.
That goes to ability to pay. That doesn't go to what his income was. I mean, those are different concepts, are they not?
Right, but I think I think you're right. It goes to ability to pay, but I also think it includes income, because if you look at it, depends on your definition of income, and to me, the definition of income is the Chapter 61 definition.
Chapter 61 talks about ability to pay.
Correct.
And it says in assessing that you can consider these, and these, but it doesn't say this is what income means, at least for purposes of alimony. It does for child support.
Sure.
Because child
sorry.
support it's a more precise, plug it into the formulas and so forth, or the guidelines chart. But alimony doesn't work that way.
Right, but sorry.
It seems to me that if you were going strictly on an ability to pay, and there's case law, if you have an acknowledgement or if it's known at the time that the payor couldn't afford to pay what was necessary to maintain the marital standard, there's all sorts of case law that says on modification, you don't have to show an increase in it. You don't have to have the agreement say that to accomplish that. But you're talking about an increased ability to pay. And I could see courts saying, look, you've got all this cash that you could be investing and even at a moderate return get more than you're getting now. And so that factors into your ability to pay. But where the inquiry is what your income is, I don't know how a court gets there.
I think because you're looking at the 6114 as the need and ability to pay, but when you're looking at alimony, the 6108.
I've read ability to pay from 6108.
Right. Well, what I'm saying is one of the factors that's looked at is what is available income. And
right. But see, you weren't going under 6114 per se. You were going under the marital settlement agreement, which said income.
Right, and then to me, the definition in the agreement is income as defined by Chapter 61, which would include available income, also known as imputed income from investable assets.
Also known as, that's not written in. I'm gonna tell you guys, and admittedly, the case law and how everybody uses the term, it's all over the place. But my feeling is, imputation of income is a term of art related to child support because it's written in the statute. In alimony, we're talking about ability to pay. And so you don't impute income per se. You say you have this ability to pay. You have this ability to earn that's available to you. This is my little thought about my little corner of the world. So no, Chapter 6108 says nothing about imputation of income.
And you're absolutely right that it doesn't use that, but the way how it's often used in a different context is when the recipient of alimony
is underemployed.
Or is underemployed or has investable assets, and then it's sort of imputed income.
Yeah, but again, I think that's incorrect. That means that their need for contribution is reduced by their financial capability. That includes the fact that they have an investable asset.
And I would agree that's true, and it should also be true that the payor spouse has the same standard imposed upon him or her in determining income and or ability to pay the alimony to the recipient spouse. It doesn't seem fair to me to use it one way or the other.
The marital settlement agreement didn't say ability to pay, it said income. And these are different terms, are they not?
Absolutely, but income also includes available income, which
Available income, not you can liquidate your house and invest the proceeds in the stock market and make a better return. Because isn't that essentially what the judge did? It said, everything you got, I'm going to charge you with 5% earnings on it?
Yes, because of the former husband, in this case, had $3.5 million in investable assets. It was basically just sitting there. It was in cash or near cash, which to me suggests, I'm not suggesting that the former husband is in any way a bad guy or anything, but it suggests that he wasn't trying to meet his obligations to his former wife to pay her alimony at the standard of living.
The trial court that the husband's investment and leaving it there was an effort to deprive the wife of income or to hide it from the income or anything of those nations. There's no such finding. Normally when we look at imputation of income, we say you have a track record. You could do this. You have not gone out and looked for a job. And here, the husband puts forth a basis why he did not do that, and there doesn't seem to be any record to suggest that the husband's reasoning was poor business or done for the ulterior motive of depressing his assets, or even that the trial court found him not to be credible on those issues. Is that correct?
I think you're right that there isn't a specific finding that he was intentionally avoiding his obligation to support the former wife. I think if you read the order, and I can't say that there was a specific finding on that. I wish there was.
When I read the order, I got the idea the trial court wanted to become a financial advisor. Because you can always look back in time and say, look, you could have made 5%. What would have happened if he looked back in time and he made those investments and he lost those assets? Then the wife could argue, oh dear, he could have put it in a much safer place.
The way how I read the order was different than that, because to me, if you look at paragraph
Finding 11?
10
and 11?
10 and 11, the judge didn't come out and say, like I said, that there was an intentional avoidance of payment.
No, in
But
fact, he
clearly-
cites in bold print, must act in good faith, and yet there's no finding that said he did not act in good faith.
Right, exactly. And to me, that the fact that the judge put that in there and then did put it in bold suggests, and all I can say is it suggests that, you know, the judge thought that the former husband here was doing that, was trying to avoid his obligations. And the evidence about what the reasons why the former husband was holding on to this cash.
Well, I understand there was a cross-examination about there was
Sure.
no contractor, and I understand. That's why I was looking to see if there was any finding of lack of credibility. You know, somewhere that I might say, okay, that this does not hold, because usually when you look at an imputation of income in those regular cases, you have your degree or you have your training. Did you put out any job applications? Did you do this or did you do that? And the trial court says you didn't do anything. And here he said, I did this for this reason, and I don't see any express challenge to that or finding about it.
I would suggest that it is implicit, and that's the best I can say. It's implicit in you know, paragraphs 10 and 11, where there's this suggestion that he wasn't doing as best he can. You know, I don't think it went as far as misconduct, but I'm sorry.
You did misconduct and be a bad investment person. I mean, I was a liberal arts major for a reason. I wanted you to handle your money.
Right.
Was the trial court using the imputation of income to decide that the wife had fulfilled her burden of being entitled to a modification based on the language of the marital settlement agreement, that there was an increase in income?
Part of it was, yes, but
It seems to say that, and I guess what's troubling me is that, and I'm not sure whether this is the same world that he lives in or not.
Well,
but,
we're not
but-
always in it.
But
It's like a Venn diagram.
an increase in income under the marital settlement agreement as compared to Chapter 61 is the trigger that lets her get an increase. And I can see using imputed income, however we wish to define that, as an aspect of ability to pay in determining the amount of the income, but I'm having a hard time convincing myself that imputed income should be part of the trigger under this agreement.
That is exactly what the trial judge did here.
Well,
but
I think we are somewhat in the same world here.
But there was also, you know, the tax returns themselves, separate and apart from this imputed income. You know, we started out with a baseline of minus $7 million, so it wasn't hard to overcome that amount to show that there was an increase subsequent to that, because his income clearly increased from minus 7.
So he made $1.
Absolutely.
You know,
Absolutely.
even though, as Mr. Manning points out, that, did you say $6 million, was it? That huge loss, tax loss, was not reflected on a tax return that was in existence at the time.
Yes. And again, Judge Altenberg, you're absolutely right that, you know, the imputation was part of the determination of the increase in income, causing the entitlement of the wife, the former wife, to have the right to have more
But
alimony.
under if you're treating it strictly as in terms of what's related on the tax returns, you didn't even have to do any imputation.
No, and that's why I think that separate and apart from the imputation shows that she was entitled to an increase. And, you know, more importantly, that just based upon substantial change in circumstances, and the equities of this case, given that his income, is higher and that he received, $2.5 million additional funds post-final judgment, shows that he had the ability to pay more alimony, and he should be required to pay more alimony because she's still nowhere near her standard of living.
Was the order with these enumerated findings an order actually prepared by the judge and his staff, or is this something that was submitted and proposed by one party or the other?
I have absolutely no idea.
The record doesn't show.
No, if it does, I don't remember.
Okay.
Let me ask you, and of course you don't necessarily know what's inside the judge's head, but if the measure is the negative millions of dollars to whatever his tax return showed at the time of the final hearing or the petition, if that's the measure, why did the judge only award your client an additional $3,000? It seems that spread would justify awarding her up to the full marital standard of living.
The reason why is because of the testimony of, and I don't remember which one it was. It was either her accountant or her certified financial planner, that was the amount she needed right now to stop her from draining her.
Exceeding a 5% withdrawal.
Exactly, and that's the reason why it wasn't more, when it clearly could have been because she needs more.
But that was not, as I understand, and correct me if I'm wrong, even withdrawing what she was withdrawing from her investments plus the 3 wasn't taking her up to the marital standard of living.
Correct.
So.
I don't know.
But you're saying that's what the measure was.
Yeah, I think the reason why the judge used that number.
Would you consider it accurate to say the judge knew that negative $6 million really wasn't what the parties were talking about?
I would hesitate to say that I know what the trial judge was saying. I am not going to answer that question.
Okay.
Thank you. If there aren't any other questions, I'll be seated. Thank you.
Mr. Manning?
Unless the court has any questions, I have nothing to add.
Thank you.
We just expected you to talk more so we begin to be sucked into the argument.
Yeah.
I can do that.
He figured he'd already done such a good job doing that first time around.
All right, thank you very much. That
Thank you
concludes
both.
our case. Court's adjourned.